Welcome. Thank you so much for joining me today. We are going to talk about the basics of consumer proposals and bankruptcies. Really, the goal here is to demystify, get rid of the shame and the stigma around these concepts and make sure that you are really educated and empowered to make the best decision for yourself when it comes to your debt. So what we're going to talk about is options for consumers who are overwhelmed by debt. What are the different options out there, and what are all the different outcomes of these different options? What is the impact on your credit report for each of these options? We're going to go through the role of a licensed insolvency trustee and some of these, like I said, these myths. We're going to look at provincial exemptions. We're going to look at the difference or similarities between a consumer proposal and a bankruptcy, the benefits of, that free, no obligation consultation with a licensed insolvency trustee, the process, and then unfortunately, we're not going to do a Q&A on this session. However, you're always most welcome to send your questions in to Bromwich and Smith. Absolutely. So let's look at assessing the right option. Okay. These are the options we're going to talk about today. So there's orderly payment of debt. There's credit counseling, debt management. There's consumer proposal, bankruptcy, and then there's the doing nothing. And I know it sounds kind of weird to say do nothing is an option, but it genuinely can be in some situations. So orderly payment of debt. This is paying your creditors. You can, in some instances, include your student loan and CRA debt, but you're paying it off your full amount that you owe to your creditor over 4 years. There is a fixed low interest rate on it. It's only 5%. This is a government program only available in certain provinces. So check, your province for sure. In Alberta, this is available. It's not available in all different provinces. With the orderly payment of debt, there isn't what's called a stay of proceedings. And I'm going to get into what a stay of proceedings is a little bit later, but that legal protection is not actually there. And when you go through an orderly payment of debt program, it will remain on your credit report for 3 years after you complete the program. So 4-year program, it's going to stay on your credit report for 3 years after that. And of course, conditions do apply. You need to be able to actually qualify for it. Credit counseling and debt management programs. Now, these are available both as nonprofit as well as for-profit. So good, bad, ugly, for-profit, nonprofit isn't actually what matters. It's, is this really the right solution for you? And again, you are paying all of your creditors, all of the money that you owe them. You've got 5 years or up to 5 years to complete that program. Student loan debt and Canada Revenue Agency debt cannot be included with credit counseling or debt management programs. So that's one, distinct difference. There are sometimes upfront fees. There are sometimes fees over the term. So you've got to look into the different credit counseling or debt management programs that are out there and what, if any, fees are involved. Again, it's a lower interest rate, but there is interest for sure. You do not get that stay of proceedings, which we're going to talk about a little bit later. And then if you go through a credit counseling or debt management program, 5-year program, up to 5-year program, and then it's going to remain on your credit report for 2 years after you have completed it. Now, a consumer proposal. This is a very powerful alternative to bankruptcy. What you're doing is you're paying off a portion of your debt, and in some instances, you are paying back 100% of what you owe to the creditor. So that it really depends on your personal situation, but generally it's a negotiated settlement with your creditors that's giving the creditors a better payment than if you had declared bankruptcy. So it's can be a real win-win that you're not having to pay back 100% and the creditors are getting back more than they would have in a bankruptcy situation. Student loans can sometimes be included in a consumer proposal, and CRA debt or Canada Revenue Agency debt can always be included and can only be included through a consumer proposal or a bankruptcy. And both are only available through a licensed insolvency trustee. And we're going to talk about what a licensed insolvency trustee is, but these are some distinct differences between the other programs and consumer proposal. 0 interest. There's no interest on your consumer proposal. You've got up to 5 years to pay it off. You can pay it off early with no penalties. So let's say your situation when you come to talk to a trustee is, quite dire. You're really feeling overwhelmed by your debt, and just affordability wise, you're not able to pay it all back. But let's say a couple years down the road, you find yourself in, a better job. Maybe you come into an inheritance or something like that, and you're like, honestly, I could pay this off. You can pay it off early. There's absolutely no penalties or no issues in that at all. You do get the stay of proceedings with a consumer proposal, which again is only available through a licensed insolvency trustee. So stay of proceedings, this is a legal binding protection for you from your creditors. Once you have actually signed into your consumer proposal, the creditors can no longer take normal creditor action. So a lien, a judgment, collection, contacting you by phone or letters or emails, like all of those threatening actions must legally stop once that stay of proceedings is in place, only available through a licensed insolvency trustee. You must be able to make your monthly payments. So it is really important that you're very, very honest with your trustee when you are setting this up. I think sometimes we try to be heroes and, say that we can afford more than we can. You don't want to get yourself in a situation where you're unable to make those payments, because if you miss 3 of your consumer proposal payments, the consumer proposal would be null and void. And usually in that case, people are now forced to go into bankruptcy because, all that interest that had been frozen, it comes back on. So you really want to be able to afford those payments. The best thing about a consumer proposal is that assets do not vest with your trustee. So one of the myths we hear quite often is, if I talk to a trustee, I'm going to lose my home, I'm going to lose my car, I'm going to lose my investments. Well, you do need to inform your trustee of what all your assets are, but they do not need to go to the trustee. They do not need to go to your creditors. So a consumer proposal is so powerful because you get to keep all of your assets. They don't vest with the trustee. You pay back a portion of what you owe. Usually you can include Canada Revenue Agency. You might be able to include student loan debt, 0 interest. You can pay it off early. I mean, this is a very, very powerful alternative. And then it will stay on your credit report for 3 years after you complete the program. So let's say it's a 5-year program. It's going to stay on for 3 years after you complete the program. Okay. Bankruptcy. Now, this is the last resort, and a trustee will be the first to tell you bankruptcy is the last resort. We really want to try and avoid that at all costs. But in some situations, that's where you need to be. That's really your situation. That was me after a really terrible car accident and owing $80,000 to Canada Revenue Agency. I really couldn't do the consumer proposal. I had no choice but to declare bankruptcy. And there is life after bankruptcy. So yeah, it is the last resort, but it's not necessarily the end of the world. So in a bankruptcy, your repayment to your creditors can be as little as 0. It really depends on your debts, your assets, and your own personal situation. So you want to have that consultation. There is a basic administration fee for the licensed insolvency trustee. This is federally regulated right across the board. So no trustee can charge you more than $200 a month for a first-time bankruptcy, as long as there's no surplus income. So the maximum you're looking at is $1,800, 9 months for a first-time bankruptcy. So you're looking at payments of about $180 to $200 per month. You do get that stay of proceedings. That's that legally binding protection from your creditors, which is like just the weight that lifts off your shoulders. The peace of mind it gives is priceless, honestly. In a bankruptcy, your assets do vest with the trustee. So this is where, depending on what sort of assets you have and how much they are, it could drive your payment up higher. It could stretch out your bankruptcy longer. It could mean that you've got to liquidate some of these assets. That's not necessarily the case always, but these are the conversations you're going to have with your licensed insolvency trustee. And it will remain on your credit report for 6 years after you complete the program. So first time bankruptcy, let's say it's about 9 months, so just under 1 year, and then it will remain on your credit report for 6 years after that. So Do nothing. Now, this is actually an option for someone who is considered judgment proof. And what judgment proof means is, your income is, let's say you only have like government income, no assets. Really, it's like you can't squeeze blood out of a stone, right? There's no way to really your creditors can't confiscate or take away any assets. They can't garnish your pay because you're on, let's say, AISH or something like that. So you owe the debt, it's not going to go away, but the creditor can't really do anything. Now, that doesn't mean that they're not going to try to. You will still get the phone calls and the demand letters. And so, this takes someone with some thick skin to be able to actually do nothing. You've really got to weigh the pros and cons. And it may be an actual option for you. It is, I think, kind of the default that we go to. And I'm hoping that after today's session, you actually take action. And if you're going to do nothing, then that's, a concerted decision that you've made. So just wanted to show you in picture. This is from the book, The Credit Game by Richard Moxley. So this image is from there, and you can see that it's about the similar impact on your credit report and how long things stay on your credit report. And one thing you may not be aware of is lates and collections also show up on your credit report as, an R7 or R5 or somewhere along those lines, R or I, and they remain on for 6 years as well. So sometimes doing nothing about our debt is also, negatively impacting our credit score. So this is just a visual to help you out on that. Now, services at Bromwich and Smith. So different services that are available. Consumer proposal, bankruptcy. That is our bread and butter. That is what we do all day, every day. That's where we are the experts. And then we can refer out for credit counseling, for debt management programs, for, a mortgage professional or other professionals that can help you out. Let's say getting out of a sticky situation with your mortgage or with your, car. A lot of people end up with negative car equity. And so we really partner and want to be helping our clients in that 360 view. If we're not the right fit for you, we want to make sure that you are connected to, a professional, an ethical professional, a reputable professional. So always great to give us a call. And we have tons and tons of education and tools that are available on our website, absolutely free. You don't have to be a client of ours to tap into these education and tools, because we really do want to be helping Canadians to thrive and to rebuild their worth. So let's talk about the creditor side of things. What rights do your creditors have? Well, that really depends on the type of credit that you set up with them. So we're going to talk about 3 different types of credit. The first one is a secured credit contract. So this is where, let's say you've got a line of credit or a loan that is actually secured to some sort of collateral. So a great example would be a car loan. You have a loan, it is attached to this car. What are the rights of your creditor if you are not able to pay back that car loan? Now, this is a little bit different depending on which province you're in, but they can seize the security, they could sue you, or they could do both. It depends on your province. So the creditor can seize your vehicle, sell it, and then just it ends there, or they could seize your vehicle, sell it, plus sue you for any remainder owing. So again, depending on your province, it's either seize and sue or seize or sue in terms of car loans and other secured loans or collateral-based contracts. The other is a conditional sales contract. So this is where the creditor still owns the goods until the debt is paid off. I think a really great example of this would be like those rent-to-own companies. You can rent to own your furniture. Technically, they own that property. You are renting it until you have actually paid it off. So they can seize that furniture or TV or whatever it is. And maybe you don't owe any more money, or the company might just say, you know what, keep the furniture, but we're going to sue you for the balance owing. So this can be seize the asset, sue you, one or the other. It's not necessarily both in this situation. Okay, unsecured credit cards. This is majority of the debt that most of us Canadians have. So if you think about like your credit cards, a line of credit that is not secured by anything, It's mostly those kinds of things, those unsecured credit products. And so in this case, the creditor can stop your service. They can begin collection proceedings, or they can sue you for the debt, and they can kind of do all three. So some examples: credit cards, utilities, bank or finance company loans, student loans would be some examples of that. So creditors can send you letters of demand. They can send you to a collections agency. And it's really important to understand that the collection agency is not really obligated to accept or report payments. Sometimes you'll make an arrangement with one collection agency, but that debt gets sold to another agency and the payment doesn't necessarily transfer over. So really great link here if you see this Canada.ca, Financial Consumer Agency, rights and responsibilities. This is a really, really great link that I recommend you check out so that you understand what your rights are against your creditors. So what happens if your creditor sues you, okay? They need to file a claim in court, and you're actually given 15 to 20 days to dispute that file. Now, if you're anything like me, you don't open those scary, those letters that come in the mail that seem scary, or the emails or the phone calls. But we got to open it up. We got to read it, because we've got those 15 to 20 days to dispute, to put in a dispute, which is great. That gives you some time to figure out your situation and figure out how you're going to deal with it. If you don't take that action, the creditor files the writ of enforcement with the court to collect from you. Court of Queen's Bench is here in Alberta. And then legal action can be taken against you, including garnishing your wages, garnishing your bank account, putting a lien against, or actually seizing your property. So it is really important. I know it is so scary when you are served or when you get that letter or that notification, but it is really important that we do take some action, just so that we can avoid some of these things, or at least delay them a little bit. Okay, let's look at a licensed insolvency trustee. It sounds really scary, and I want to take away that fear for you, okay? So a licensed insolvency trustee, they have access to a different array of products and solutions that they can offer you. It's really a consultative opportunity to really look at where are you at right now, what are your goals, what's keeping you from that, what's your current situation, what are the different options that are available to you. They will speak directly to your creditors and handle that for you, which is so great. Licensed insolvency trustees are federally legislated and federally regulated. This is really important. And I say that, no matter what option you choose, check those credentials, check to see that there's a governing body of some sort, just to protect yourself. A licensed insolvency trustee is not on the side of the creditor, nor are they on the side of, the consumer. And there's a lot of myths out there saying that the trustee works for the creditor. In fact, the trustee is an officer of the court. And what they are doing is they're trying to balance both sides and really look at both sides and do the best that they can as an officer of the court for both parties. So this is really, really important. A trustee is federally regulated. They are paid from the estate that is being administered, and they are not paid by any one party. They're not paid by the creditor. They're not paid by you. They're paid by the work that they do. And again, this is Canada-wide. This has been, this is our right as Canadians. It is a legal process. And there are 4 key tenets that the licensed insolvency trustee is to uphold. And the first is rehabilitation of the consumer, right? Like, there are things that get us into trouble: job loss, divorce, death of a spouse. These are kind of the things that really get us from managing our debt to being overwhelmed by our debt. And we want to make sure that whatever those situations are, that, the client learns from that, can grow from that, can do better going forward. And it's not a blame or a judgment thing. It's just, let's help you build some good financial habits so that you can avoid this in the future. The trustee is to take control and distribution of the assets for equitable treatment of the creditors. This is really important. We're not favoring one of your creditors over the other. We're not overpaying one creditor. The trustee is responsible to make sure there's an equitable disbursement to the creditors. The trustee is responsible to investigate. We're going to look at the last 12 to 24 months. What has your activity been? Have you maybe favored one creditor over another? You know, those sorts of things. How has the creditor been? Have they done anything that was offside? So trustee needs to do their investigation. And then finally, we in Canada are a credit-based society. Credit is not going away. So we really want to promote confidence in that system. And that's why, as Canadians, we have an exit strategy. That's why we have licensed insolvency trustees, so that we can keep that balance and keep that confidence in our system. Okay, some bankruptcy myths, okay? So there are certain things that are exempt in your bankruptcy, and there are certain debts that will not go away just because you declared bankruptcy. So exemptions in your bankruptcy is a certain amount of equity in your home, a certain amount of equity in your car, household items, tools of the trade, anything that is registered. So RRSPs, all of those registered life insurance policies that have a named beneficiary, a specific beneficiary, seg funds. There's all these different things that are exempt in a bankruptcy that you don't have to give up because you've declared bankruptcy. On the other side, not everything just gets washed away, right? If there's a fine or restitution, if there's a court order, anything that the creditors would have been privy to, or would have had the right to had they known about it. Sometimes student loan debt doesn't necessarily go away. It depends on how long you've not been a student for. So really important to understand that there are certain assets that are exempt in a bankruptcy, and there are certain debts that don't go away just because you declare a bankruptcy. And you want to have that conversation as well in your consultation. So these are all false. You don't necessarily lose your home or your car or all your investments just because you are declaring bankruptcy. And again, remember, bankruptcy is the last resort. Consumer proposal is a very, very, very powerful alternative to bankruptcy. Here we go, a little bit more detail on the kinds of things that are protected in a bankruptcy and the kinds of things that won't go away. Anything that's done fraudulent, any type of theft, a fine or restitution, these things are not going to go away. Anything that was done with false pretenses. So these will not go away. But again, if you look on the other side, equity in your home, life insurance policies, clothing, personal effects, a certain amount of vehicle. I mean, again, you got to understand, we want to have confidence in the system. We want to rehabilitate people. So if we completely strip you of everything, how are you going to rehabilitate, right? This is just an example of the exemptions just in Alberta. If you go to our website, we've got all of the exemptions for all the different provinces. So I would say definitely check that out. All right, similarities and differences between a consumer proposal and a bankruptcy. So in both, you are getting that stay of proceedings, that legal protection from creditor action, so that they are not able to call and threaten and put a lien against you or a judgment, those sorts of things. Once you've signed into your consumer proposal or bankruptcy, you get that stay of proceedings. So that's something both of them have in common. It is a discharge of unsecured debt only. So if you recall, we were talking about different types of debt. Unsecured debt can be discharged through a consumer proposal and or a bankruptcy. And both can only be administered by a licensed insolvency trustee. So it's really important, if you're talking to someone and they bring up a consumer proposal, you want to make sure you are talking to a licensed insolvency trustee, because these programs are only available through a licensed insolvency trustee. Okay. Some differences or commonality, different things you can kind of see in a bankruptcy versus a consumer proposal. So in a bankruptcy, you may be required to make your payments to the trustee. You are required to make them to the trustee for equal distribution to your creditors. You are required to attend 2 mandatory counseling sessions, just so you can talk a little bit about budgeting and consumerism, and just kind of start that journey of rehabilitation, of getting some better financial literacy and some great financial habits, right? And just even looking at your current financial habits and how do you go from where you are now to where you want to get to, okay? You need to track your income and expenses monthly. You want to make sure that your taxes are paid off and are up to date. You're going to assist the trustee in any documentation that is required. And then in most cases, first-time bankruptcy, no additional income. You will be discharged after 9 months of filing. On the consumer proposal side, very, very similar. You're still going to attend 2 mandatory counseling sessions. You do have a fixed payment over that term, which you can pay off early with no penalties. If 3 payments are missed, that consumer proposal is annulled. Usually that means you're going to have to declare bankruptcy. So you really want to be mindful of that. And once all your requirements are fulfilled in a consumer proposal, you're going to get a certificate of completion. And the neat thing is you can actually be rebuilding credit during your consumer proposal, whereas in a bankruptcy, you're going to have to wait until you are discharged. Now, caution on that. You want to make sure that as you're rebuilding credit, you're not getting yourself back into a slippery situation. We do not want repeat clients. So again, work with your trustee on that. Okay, what are the benefits of your confidential, no obligation consultation with a trustee? Well, first of all, it is completely free. There's no cost and there's no obligation. So make that phone call, have that conversation. It's an opportunity to share your personal situation with a professional. Maybe you've talked to a friend or family member, but their situation is not your situation. You are speaking to an objective third party who is an expert on debt. So that's a really big advantage of the consultation. It is completely confidential and discreet. You or your clients are, going to get this non-judgmental, compassionate help and the facts that you actually need to be able to make an informed and empowered decision about your finances, about your debt. And you're going to be able to learn all the different options that are available, with a trusted professional. And if we're not the right solution for you, a licensed insolvency trustee is legally bound to refer you to the right option for you. So that's really important. Here is our process at Bromwich & Smith. We have one toll-free phone number, or you can use our email address. Get in touch with one of our amazing and compassionate debt relief specialists. They're going to treat you with grace and respect. They're going to provide you with impartial and unbiased information. And either they're going to refer you out to one of our trusted partners, or they're going to recommend a consumer proposal or a bankruptcy. And then once you decide which way you want to move forward, they will prepare the file. They'll set up a video appointment for you all across Canada except for Quebec. Once you have signed, you've got that legally binding protection, that stay of proceedings, and you can really start to rebuild your worth and see that relief and hope. And that's what, our clients will often say to us is, I wish I'd called sooner. I feel so relieved. The stress is off of me. So this is my contact information and just a little brag on Bromwich & Smith. We've won a few. Oh, sorry. This is how you can find us, on social media, all of our different handles. We're very active on social media and we'd love to connect with you. And I think this next one will be, yes, a few awards we've won. So, a high Google rating at 4.9, 3 best rated. We've won the Better Business Bureau Torch Award, the Reader's Choice Award, many, many years in a row. So lots of awards and accolades and a lot of really great testimonials out there for you to check out. So that's us. If you have any questions, get in touch with us at inquiries at bromwichandsmith.com or referrals at bromwichandsmith.com. If you would like to partner with us, also get in touch with us. That way, if you are, an organization that's helping individuals and you're dealing with people that have some financial strain, feel free to get in touch with us. I hope that this webinar was useful and informative. Thank you so much for your time, and visit us again and get in touch with us. Thank you.